Okay, so I hope you all enjoyed your lunch, and I'm glad to welcome you back to my panel, where I'm delighted to welcome two excellent speakers. To my right, I have Mrs. Justice Bacon, and on the left, I have Judge Marc von der Woude. Okay, so Kellen, you are the President of the UK Competition Appeal Tribunal, and you're also a judge at the High Court of England and Wales. And Marc, you are the President of the General Court of the Court of Justice of the European Union. The format that we thought about is that first Marc will give some thoughts on a more general level about the presentation and importance of economic evidence at the General Court. And following that, Kellen will give insights into the application of economic evidence in two concrete cases, one at the High Court and one at the Competition Appeal Tribunal. And then afterwards, we will have a discussion. So I'd like to ask Marc to start with his presentation. Thank you.
Good afternoon. Thank you, Philip, for this introduction. Yes, as one always says, after lunch is a bit of a difficult task, especially if you have a very general topic dealing with law and economics, or the interplay of both concepts before the General Courts and the Competition Appeal Tribunal in the UK. Law and economics, it's a recurring theme, which makes sense. I mean, if you do competition law, you speak about markets, and when you speak about markets, you're sure you will find an economist around. So it's normal that we have these type of discussions. I also noticed that in the previous editions of this very same conference, the issue of law and economics, economic evidence, comes up again. And each time you have this discussion, I had a look at last year's conference. There was a discussion between Peter Roth, a lapsus. And yes, as you know, I like his books. And Mrs. Marculi of the General Court, and today we have Kalin Bacon and I. Of course, I could have asked Anna Marculi to give her notes and reproduce and recycle in the green economy the same things she said last year. And she was so kind to share her notes with me, but I will not read them out again. I don't know whether she will ask copyright royalties for that, so I didn't know to the extent to which she would charge me something. So I prefer to have a more wider topic and not to incur that risk. I will focus on the trends in competition law when we speak about law and economics. And there I have an impression or an intuition, which I would like to share with you. I have this impression that the era where we use in our work economic effects or economic standards is gradually decreasing. Basically, that we passed the zenith of a more economic approach and that we are entering into something new. And I could say that an era of ethical standards rather than economic effects standards. But that's just an intuition, and I have a few elements which I would like to share with you to support that intuition. But before I do that, I would like to say three things about our court. First, the General Court is not a competition law court. It is a general court. And we deal with many other issues, and competition law issues are just part of it. And what I notice is that the number of competition cases continuously decreases. For example, in 2025, we had around 12 cases. In the meantime, we receive around 7 DMA cases, TSA cases. And the question arises, do we count them as competition law cases or not? Because the legal basis is Article 114 of the treaty, and that's not competition law. So that's the first point. So it goes down. And secondly, when we deal with competition law cases, we're dealing with them in a very peculiar way. We are not looking for the objective truth or whether something really happened. We exercise legality control on the basis of the pleas and arguments put forward by the applicants. So even if the case is rock solid, it can be annulled and vice versa. You can have a wobbly case which is upheld. It depends on the arguments put forward. And third thing before I go to the question about the intuition is that the General Court deals with cases. It doesn't have a policy. It doesn't have an agenda. We are not there to validate a specific economic theory. We're just judges. So now the key question. Are we turning into an era, a new era, a more ethical era in competition law, EU competition law? Of course, if you speak about something new, you have to speak about the old things. And I'm looking to the older people in the room. I see a few of them, which comforts me. So I think we had three eras. We had the founding years, between the 60s and I would say late 80s or mid 80s, where the system was established, the period of Regulation 17, a very formalistic approach, and I still see at this place, I think, Jean-François Verstringen, who was the head of cabinet of Peter Sutherland, saying, everything has to be put under Article 101.1, and then we can regulate under 101.3, or 85.3, as it was called at the time. Those were the founding years, a very formalistic approach to trigger community competence to deal with certain industries. That changed. So at the end of the 80s, 90s, first by the courts, then by the authorities themselves, and it became, say, a phase of transition which saw cases like air tours, the adoption of Regulation 1/2003. And now we are a step further. I think we are in a more economic period where we saw the guidance paper, and I think the zenith is Intel 2 in 2017 by the Court of Justice. But is the tide turning? Is it the zenith in Intel 2? I think I have 5 elements which I would like to share with you, which I think justify that impression. First, there is the enforcement issue. If you deal with sophisticated effects doctrines, it takes more time. And as I say, a counter-reaction, we have seen, for example, the adoption of texts like the DMA and DSA, which are reminiscent of the old formalistic rules we had in the 1980s. For example, if I refer in particular to regulation, the DMA regulation, if you take recital 23, when it comes to rebut, say the presumption that you are a gatekeeper, and I quote, any justification on economic grounds should be discarded. That's hard to swallow. And it's basically, it's not competition law, it's something else. The second point I would like to mention is that we see that in the case law itself, economic concepts are losing their relative importance. First, for example, the AEC test, which was at the core in the Intel case, or Intel saga, is optional. If you read recitals 339 and et sequies in the Intel 2 judgment of the court, validating, say, the judgment of the General Court on the concrete application of the AEC test, it says, yeah, the case is limited to this, but effects can also be shown in another way. And you see in other cases this being confirmed. I refer in particular to Qualcomm 2 as regards the relevance of the test in price squeeze practices, Unilever Italia, and more recently, Google AdSense. Then you have concepts which are more traditional, market definition. For me, and I think for many people here in the room, it's the SNP test. The SNP test of the notice of 1997 and now the new notice. But that's also optional. Read ThyssenKrupp, read Qualcomm 2 of the General Court. Moreover, there is a tendency that even the demand side, as the point by which you start to define the relevant market, is not necessarily relevant. Look at Servier. It's not the therapeutic use which is put first. It's the molecule which is put first. And a molecule can be used for various purposes. And sometimes you even say there's no need to define the market whatsoever. Google Android Italia, for example, on the downstream market for the juice bars. No need to define the relevant market. So AEC, market definition, and let us speak about efficiencies. I think they received the coup de grâce, as they say, in the CK Telecom case. So concepts which were there in, say, the previous practice are being put in a very different perspective than we initially thought. So that's the second intuition, or second element, which makes me think like that. The third is, of course, an issue which was debated very often in this very room, the object box. The object box becomes basically the starting point, or say the analysis by default, when you have a competition case. At least that's the impression I have. That the case law says it has to be interpreted narrowly, but de facto it is very, very broad. Moreover, when we speak about the object box, the intent of the parties to the agreement doesn't really count. And on top of that, again, in Servier, there is no need to show, on the basis of prior experience, that a specific agreement is by its object restrictive. It can be established in another way. So the object box becomes, I think, the standard, say, point to approach a restrictive case. The fourth element is the way how this object approach has influenced Article 102. For example, if you have a look at the Football League case, December 2023, you see a perfect parallelism between, on the one hand, 101 and 102. 101.3 being the objective justification which the courts developed already in the beginning of the 90s, for example, in a case like Hilti. So if there is parallelism between 101 and 102, does that also mean that, for example, the object idea, that the restriction by object also infiltrates in the analysis of Article 102? And for example, if you read the case on naked restrictions, the decision on which the General Court will take a judgment tomorrow as regards the naked restrictions which were not affected by the Intel saga, it's called naked restrictions. It's reminiscent of an object restriction. Then, basically, if you read all that, are we back to Hoffman-La Roche? If the object restriction is also possible under 102, what about the relevance of Intel 2? It's a question I have. I don't have an answer to it. That was the fourth element. And the fifth is perhaps more fundamental in nature. When I have a look at the language in recent cases, they are very normative, ethical in nature. Competition on the merits, it's a thing which is systematically cited. I had not the impression that it was so, for example, the first decade of this century. Fairness considerations. A case like Google Shopping. It's unfair to prefer your own products and to downgrade the products of your... Indeed, it calls back on standard ethical concepts, but that's more normative than, say, economic. And then, for example, the football case, dealing with conflicts of interest between the football leagues and the new one which wants to set up a super league. So there again, typically legal elements. Now, how does it come? It's perhaps that we are facing specific types of dominance which have reached so much of our societies that we're basically using the concepts for exploitative abuses, fairness, discrimination, or is it something else? I don't know. Again, an intuition which makes me think that we are entering a new phase, a more ethical phase. So those were the five elements which I would like to share. But does that mean that this is the end of the more, say, the role of economists in competition cases, in particular before our court? Not at all. I think first, the concepts are still there. If there is an AEC test being used, either by the authority or by the defendant. We must engage. That will remain. Second, the functioning of markets is key in any competition case, and can be decisive. First, to understand where the conspiracy starts and where normal market parallelism stops. Woude, CISAC, those type of cases. So that will remain. And on a more personal note, I think there is a new area to be explored when it comes to environmental issues. Dealing with externalities, the costs, how do they fit in Article 101, Paragraph 3, and how can we use that? I think there is a lot of work to be done in future case law. So there is still enough to debate on law and economics at this conference, and I'm sure at the next edition of this conference next year. I thank you very much for your attention.
Can you hear me? Okay. Yeah, thank you very much. I think we'd like to defer the discussion until Kellen has had a chance to speak. And I'm particularly glad that she's going to move from the very enlightened, broader view, I think, to a different perspective, a perspective of some concrete cases. Kellen, thank you.
Good afternoon, everyone, and thank you for inviting me to speak at this conference. I've been asked to speak about the interplay of law and economics in the Competition Appeal Tribunal and the High Court. Both of those are jurisdictions where, perhaps unlike some of the practice in the General Court, economic evidence features very heavily. And with that in mind, I've been asked to talk about two judgments from earlier this year. My own judgment in a High Court case about small plastic toys, and the judgment of some of my CAT colleagues in a case about car safety components. Now, unsurprisingly, the two cases were very different. Cabo was an abusive dominance allegation. Stellantis was an alleged cartel overcharge. The common theme was that in both cases, the claimant's expert evidence on the critical issues of loss and damage was found to be unreliable and unprobative. So what went wrong? Let's start with Cabo. The founders of Cabo were two families that went on holiday together. Their children got hooked on watching videos of other children unboxing toys. So the two sets of parents came up with the great idea of designing a range of collectible toys with a world theme called Worldies, with a surprise unwrapping experience. A financial backer agreed to provide the capital investment needed to get the business off the ground, as well as the back-end logistics infrastructure and contacts in the toy industry. And their design looked like this. I've put it up on the slide. Once unwrapped, it contained figurines like these. What Cabo hadn't reckoned with was the stratospherically successful product, LOL Surprise, manufactured by MGA. MGA decided that Worldies was a copy of LOL and threatened the main UK toy retailers that if they stocked Worldies, then MGA would cut off their supplies of LOL Surprise. Well, at the time, LOL Surprise was the second best-selling toy in the whole of the UK, in any toy category. So, unsurprisingly, the main toy retailers gave in to MGA's threats and agreed not to stock Worldies. Eventually, Worldies was launched in a discount retailer. It did sell fairly well for a few months, but then the market lost interest. It was soon clear that the product failed, and the financial backers pulled the plug. Enter the lawyers and the economists. Cabo issued a claim against MGA, claiming abusive dominance, leading to lost profits of over £170 million. It said that but for MGA's unlawful conduct, Worldies would have been a very successful product, and Cabo itself would have gone on to be a successful toy business. Well, following the trial last year, which finished at the start of this year, I concluded that MGA had indeed abused a dominant position in the market for surprise collectible toys by threatening to withdraw supplies of LOL Surprise in order to exclude Worldies from the market. But the problem was in showing loss. Cabo's economist had done what he'd been told to do, which was to model the profits that could have been expected if Cabo was a very successful toy business. He estimated profits by using a Bertrand simulation model, which assumed that the success of Woude's Woude in the counterfactual case have been similar to that of various comparator sets, which he plugged into his model. MGA's expert did not construct a simulation model, but simply calculated what Cabo's profits would have been if it had achieved the same level of sales as various other comparators. What both experts were doing in different ways was to model different degrees of business success. As you'll see on the slide, Cabo's expert modelled various flavours of very high success. MGA's expert modelled some successful and some less successful scenarios. But the problem was that none of this addressed the key questions on which the entire quantification exercise rested, which was how successful Cabo would have been if it had not been excluded from the market. Indeed, would it have been successful at all? Would it have made any profits at all in the counterfactual case? Neither of the economists could answer those questions. That was, as they made quite clear, not their area of expertise. They weren't toy experts. But without answering those questions, their evidence was in the realms of complete speculation. There was no point modelling a level of success that was completely hypothetical without having any idea whatsoever of whether Cabo would actually have achieved that level of success. The only evidence on how successful Cabo would have been had it not been excluded from the market had to come from the factual evidence of the parties themselves and the toy industry experts. And on the basis of my assessment of all that evidence, I concluded that Cabo would not have been successful and would not have been profitable even if MGA had not intervened. And this slide summarises the main conclusions I reached on that evidence. And unfortunately, that made the expert evidence on quantum, meticulous as it was, and at the great expense at which it had been prepared, almost entirely irrelevant. I say almost because MGA's expert did provide some useful information, because he showed that even if Woude's had been as successful as a significantly successful comparator toy, it would have been either loss-making or only marginally profitable. And that supported my conclusion that Woude's was never likely to have been a profitable business. With a great deal of hindsight, and hindsight is always a wonderful thing, the expert quantification exercise should probably not have been carried out, at least at that stage. It should have been apparent that asking the experts to model theoretical scenarios was going to be of very little use to the court. What I think, again, with hindsight, the party should have done was to ask the court to reach the factual conclusion as to the likely level of sales in the counterfactual case based on appropriate comparators and the evidence before us as to Cabo's business model. And that would have produced a decision on whether Cabo would have been profitable on that level of sales. That would have required some economic or accountancy evidence, but far more limited than the quantum exercises that the experts did in this case. If the facts had shown a likelihood of profitability, which they didn't in this case, but if they had, the experts could then, of course, have been asked to model the quantum of damages based on the counterfactual level of sales determined by the court, and that would have produced meaningful evidence grounded in the facts. Let's turn to Stellantis. This was a very different case involving an alleged cartel in the market for car safety components, specifically seat belts, steering wheels, and airbags. And although the claim was technically a standalone claim, its starting point was that the Commission had found that the two defendant groups had been involved in cartels concerning the same products, but in relation to different manufacturers. And the claim in the CAT this time rested on three pillars. First, if I can get up my three pillars, great. First, an inference from the Commission decisions to the effect that if the defendants communicated with each other in relation to supplies to certain manufacturers, they must also have done so in relation to Stellantis. Second pillar, reliance on documentary evidence to show that the defendants' activities targeted supplies to manufacturers other than those named in the Commission decisions, including Stellantis. And thirdly, reliance on econometric evidence to show that the prices charged to some of the claimants during the cartel period were higher than during a later clean period. Now, the tribunal's conclusion on the basis of the commission decisions and the documentary evidence, so that's the first two pillars, was that although it thought that there had been a cartel, it couldn't conclude that the cartel activity was more than sporadic during the alleged period or that it resulted in an overcharge. So the claim then came down to the econometric evidence to inform both the question of the ongoing existence of a cartel during that period and the quantification of damages. Now, Stellantis had relied on a regression model which purported to show the following overcharges. But there were three main problems with that model. First, Stellantis' expert accepted that while his model showed higher prices in the cartel period, it didn't show that the cause of those prices was a cartel. Secondly, the regression model was in any event unreliable, the tribunal found, because what Stellantis' expert had done was to specify the model differently for seat belts as compared with the other two products. If the model was rerun, using the same specification for seat belts as for airbags and steering wheels, it produced quite different results shown here, indicating not an overcharge, but a very substantial undercharge for seat belts. And there was no explanation, the tribunal found, for that strange result. So the tribunal concluded that the only possible cause was that there were omitted variables in the regression model, which showed that the regression model was not robust. And that led the tribunal to conclude that the recorded overcharges for the other safety components, airbags and steering wheels, were equally likely to be due in whole or part to omitted variables rather than due to the operation of a cartel. So that's the first two problems. The third main problem was that the defendant's expert carried out a sensitivity analysis on the model, combining the two cartel periods that the model had assumed, on the basis that there wasn't any particular factual basis for separating those periods. And the combined period analysis produced an odd set of results set out on this slide. As you'll see, for airbags and seat belts, the very substantial overcharges or undercharges produced by the Stellantis model reduced to figures that are entirely minimal. And there was no obvious reason for these completely inconsistent results. As the tribunal pointed out, the calculations are based on the same model, with the same data, the same control variables, and comparing the same clean and dirty periods. And the only difference was whether the dirty period was treated as a single period, so the first two rows of the slide, or broken into separate periods, the last row. Those problems led the tribunal to find that no useful conclusions could be drawn from the claimant's econometric evidence. The claim therefore failed. As the tribunal said elsewhere in the judgment, there were limits to the extent to which it could deploy a broad axe. At one level, this was an example of the expert process at least working the way that it's supposed to do. The claimants put together their case and the economic model which they relied on to support that case. The defendants had full access to the underlying data, and they were able to critique the analysis done on the basis of those data. The tribunal was then able to decide whether the defendant's criticisms were valid or not. And it did all of that. But what the case does expose is the need for the experts to engage meaningfully at an earlier stage in the proceedings with the criticisms of their evidence, rather than simply digging in and defending the analysis done. It was, or perhaps should have been, obvious to the claimants and their expert long before trial that there were at least some quite serious problems with the regression model, and there should have been a meaningful and objective consideration of those problems and a serious attempt to resolve them. And if they couldn't be resolved, then objective consideration should have been given to whether the claimants would continue to rely on the regression model, at least specified in that way, at the trial. The two cases expose different types of problems with the use of expert evidence at trial in some of these cases. Thank you. The first problem is the danger of putting forward a hypothetical model which is not grounded in the facts. In my view, there's not a lot of point embarking on that sort of exercise. An expert should not, in principle, be asked to do it. The expert modelling should, in principle, start with the facts. And this is a point emphasised in the new CAT practice direction on expert evidence. If the facts are disputed on central issues that are the foundation of the expert modelling, then the better course is to split the trial, if that's possible, rather than spending a lot of time and money on a potentially redundant exercise, as happened eventually in Cabo. The second problem is over-reliance on a model that is quite fragile and works only on particular specifications. As you've seen, that was the problem in Stellantis. If you do find yourself relying on inconsistent specifications on the model to get it to work, or if sensitivity analyses produce results that are very different to the base case and quite difficult to explain, then those should be red flags suggesting that there may be something wrong with the model which needs to be explained up front and dealt with at trial. Ploughing on and hoping for the best is perhaps not a sensible strategy. It's particularly risky following the new CAT experts practice direction, which states that the expert should disclose any initial analysis that materially informed the subsequent choice of methodology, particularly if the early analysis produced a result contrary to the interest of the expert's client. So it's a show your workings direction. The third problem is the question of how to respond to critiques of a model, where those critiques put forward what are said to be fatal flaws in the model. And there's often a temptation at that point, it's entirely understandable if you've done a lot of work, to respond defensively. But what is really needed is to step back and confront the fact that the court might not agree with you. What does that do to your case? If it brings it crashing down, is there a plan B? Can you re-specify your model on a different basis? Or put forward an alternative model which might be more reliable, even if it doesn't get to quite as large a damages figure? Ultimately, as I've said, economic evidence is central to many of the cases that we deal with in the High Court, and almost all of the cases that we deal with in the CAT. And the High Court and the CAT want to help parties to produce good, clear, and relevant economic evidence. We rely on it, and it's important to the cases before us. That means providing a robust analysis in clear and simple terms with compelling answers to any criticisms of that analysis, and if necessary, providing an alternative approach as a backup plan. Provide the judge with an easy way through to the conclusion you've reached. The judge will thank you for it. And above all, use your evidence to tell a story that fits the facts before the court. Thank you very much.
So fantastic. Here we are at a conference hosted by a competition firm and competition economics firm. And we hear that the age of competition economics is behind us. And then we hear that when economic evidence is provided, it's useless for the court. So I'm particularly grateful for the last slides, which try to be polite to the hosts. But let me challenge some of this. So I'd like to start with Marc. So one of the motivations for the simpler criteria that he was referring to, that, for example, appear in the DMA for designation of being a gatekeeper, where that the decisions could be taken more quickly. So I'm just wondering, at the General Court, is it actually the case that the incorporation of economic reasoning and economic expert evidence during the high time of economics, did it actually lead to a lengthening of the cases? For example, in Intel, is the reason why Intel was so long, is that due to having to deal with economic evidence?
Thank you, Philip. I don't have data which allow me to make an informed decision about it. So it's just I have not calculated how much time the colleagues in both courts spend to analyze all the economic studies. But I think it's a fact of life that if you have more sophisticated evidence, it takes longer. I think it's a simple fact. However, would the Intel case have lasted as long in the absence of the economic study? That, I think, is the counterfactual question. I think the case dates back to the past century. We had a discussion over lunch on this. Took the Commission quite a while. The General Court was pretty fast. Then there was the Court of Justice. And with all due respect for the Court of Justice, it changed its case law. So the case had to be sent back. And the operative part of that judgment, to say it politely, is not particularly clear. So it led again to all sorts of litigation, and we will have, to say, the Intel 2 or Intel 3 or whatever it is judgment tomorrow on the, the naked restriction. So I don't know whether, to answer your question, whether the fact that we had to go through all the number crunching was really a delaying thing. There were more profound causes as well, I think, and the fact is that it has been a change in the case law.
And just following on from that, would you say that it's possible to make a general statement whether economic reasoning and evidence leads to more or to less legal certainty as concerns the lawfulness of firm strategies?
There again, that's a philosophical question. I think if lawyers prefer, at least most lawyers prefer hard and fast rules. Whether they are satisfactory is another question. Hard and fast rules, you read the case, you read the black letter law, and you apply it to the facts, and that's it. That goes faster than having to make an analysis where the answer is still to be found and where everything depends on many variables. So, yes, as a general statement, I would say legal certainty benefits from clear rules, even if that clarity may go to the expense of the acceptability of the norm, which is another question.
Okay, thank you. I'd like to turn to Kellen. My first question on Cabo is really about curiosity, what happened. So did the guilty party sort of get out of jail for free here? Since you were ruling on damages, but you found that there was an abuse found.
Well, the Court of Appeal might decide that. Yeah. Unfortunately, we're not a regulator, we're just a court. So cases come to us, and if a claim fails, it fails. Unfortunately, that is the case. Had things turned out differently, let's say there'd been a split trial on liability and quantum, and we then stopped after liability, contrary to MGA's protestations, that it hadn't abused any dominant position, and indeed the market was defined quite differently to the way that Cabo had suggested, then the outcome could have been different. Cases very often settle, and that might have done. But the problem for Cabo was that it was all in one trial. I think, though I'm not entirely clear, that may have been at Cabo's insistence. I wasn't involved in the earlier stages. I know that one party suggested a split trial, but ultimately it was a single trial. And so, yes, in a way, MGA doesn't bear a penalty in terms of damages because it has succeeded in proving that there was no loss. And it's the same with Stellantis, and there's a finding in Stellantis that there most likely was a cartel. The defendants hadn't done a particularly good job of rebutting the inferences that could be drawn from the documents, but ultimately the evidence wasn't there to show that the cartel was anything more than sporadic. So I think the answer is that yes, in a litigation scenario, when you are bringing a claim based on loss of profits, as in Cabo, or an overcharge, as in Stellantis, and you fail to establish that, then the wrongdoer, if you like, doesn't have a penalty. And that's because we're not a regulator. It's really for the CMA, if it wishes to investigate those cases and impose a penalty. Whether there's no cost, I mean, in both cases, they went through very expensive proceedings and they didn't get all their costs back, as is the norm these days. So it's not as if there was no cost to them ultimately.
Okay. Then let me move on to your main point, which is your emphasis that the experts should engage with the facts of a case. So I've read the practice direction that was published last week, I believe. And there was another paragraph which said that for econometric evidence, ideally models should be defined before the data is seen. So there seems to be some tension between these two goals, and I'm just wondering whether you could elaborate on.
Yeah, I think that's because there are different kinds of economic evidence that we get, and we've seen a whole variety of different kinds of evidence that were deployed in these two cases. In Cabo, we weren't getting econometric evidence. And effectively we've got some financial analysis. We had in the market definition piece, there was some revenue correlation analysis. In relation to the profits analysis, there were, as I've said, various different kinds of models, a simulation model, another model that didn't simulate, that were simply estimating profits. None of that was a regression analysis. And I think that for that kind of economic modelling, it's totally fair to say there's no point if that doesn't fit the facts. So here's an example. There was a revenue correlation analysis done in relation to market definition for MDA, and it compared revenues of one set of products with another set of products to see if revenues in one rose and fell in another, then one would draw an inference that there was switching between the two products. But the problem with that, and it's set out in the judgment, is that it produced some results on market definition that simply didn't correspond with the observed reality of the market. For example, there was some products excluded, which on any basis one would have said were close substitutes for the focal product. And there was no explanation for that, except to say, oh, well, this revenue correlation analysis doesn't really work at all levels. But then the question is, well, why do you rely on it? So I think the problem is that when you are doing that kind of analysis and it spits out results that simply don't fit the facts, the court is going to question that and ask how reliable it is. The other problem in Cabo is doing an entirely hypothetical exercise where you say, well, let me just take kind of an example of a very successful product, model what the profits would have been if this product in question had been successful on that degree. Well, what does that tell you if you don't know the prior question of how successful would it have been? I think regression analysis is a bit different when you're using that to do something like try and quantify an overcharge. And I think the point that's being got at here in the expert practice direction is that you don't want somebody coming along and saying, well, I've done all these different kinds of analysis, which I'm not going to show you. And I've eventually found one that will give me the right result, and that's the one I'm going to put before you. And then the court or tribunal doesn't know, or however many other specifications of that would have got to completely different results. It's much better if they come along and say, well, look, here's the analysis. I've got a hypothesis. I'm going to test that hypothesis on the data that I now have, and then see if that matches, if the regression result I get out of that matches my hypothesis. But I think we're just talking about different kinds of modelling and different, there's facts in terms of facts of the case, and then there's data that you plug into your regression model, and that's the distinction I think being drawn.
Okay, thanks. No, I'm actually very pleased to hear Kellen speak with a lot of independence of thought, which I think is one of the great strengths of the court systems. Let me just come back to Marc for sort of one final question. So it's about the different paths that the US and Europe seem to be taking, which you can see embodied in the DMA. So in the DMA, the US seems to rely more on established competition law and guidance when dealing with digital markets. Whereas the introduction of the DMA in Europe has strong regulatory nuances. So from an economic point of view, you could interpret that in the following way, that the US perspective seems to be one which sees several large digital firms in vociferous competition with each other, a situation which is principally beneficial, but should be monitored for traditional abuses. Whereas the European perspective, in my view, sees a large firm as owning its own digital platform to which access must be ensured. So this would be my summary of the different perspectives. So I just wanted to hear from you, from your long experience. Would you be able to comment on the merits of each of these perspectives?
No. What I can say, perhaps, again, is a bit avoiding the question. Norms are basically, they grow in the societies, they reflect society. Let's be fair. We are technology takers. They are the technology makers. In the United States, they compete, they make it. We take it as a given. We have a more static view. I think that may be one explanation of the phenomenon. And secondly, we are still more protective of society. The DMA, DSA protects. It protects consumers. When we speak about the DSA, it protects perhaps competitors, newcomers, in order to foster, say, upcoming competition. We do it now, but nothing is carved in stone. If you have a look at the Robertson-Patman Act, it may be lettre morte today, but in the 1930s, it was most welcome. And tides turn and everything changes. So it could well be that in future, a new administration will also take up that old legislation again. What will happen with the United States when the Chinese overtake them? We don't know. I think that we will see what kind of new norms will be developed at that time and how the US will react to being overtaken by the Chinese. We don't know. So that's the fascinating thing of law and economics, I would say.
Okay, thank you. Thank you very much for the discussion. I really enjoyed it. I hope you did too. And yeah.